Hi there. It's great to have you back on my CryptoQ Media channel. Following a mixed decision on the defendant's application for summary judgment, the judge in the Zakano vs. Ripple complaint case sent the matter to a magistrate judge for possible settlement. As the parties sought a settlement in the XRP immunity, Ripple class action litigation, the judge disregarded the Southern District of New York Court's judgment that XRP programmatic sales are not securities. This led to a bitter debate. The class action case concerning Ripple XRP and CEO Brad Garlinghouse was decided by Judge Phyllis Hamilton of the Northern District of California District Court. Plaintiff Stostick sued the defendants under California law for an individual claim, but the court rejected the defendant's request for summary judgment on the federal and state class claims. Another thing to think about is this. It was determined that the testimony of Stephen P. Feinstein and M. Laurentius was immaterial, rendering both the defense and plaintiff moves to exclude it moot. In a supplementary order, Judge Phyllis Hamilton asked that Magistrate Judge Robert Ellman be sent the Ripple matter so that the parties' dispute may be further addressed. Judge Hamilton overturned Judge Torres' summary decision on the sale of XRP software from the Southern District of New York. Investors were relying on Ripple's endeavors to produce profits, he said. As the XRP army speculates about how Judge Hamilton's decision to bench Judge Torres would affect the Ripple v. SEC action, concerns regarding XRP's classification as a non-security asset have grown. Judge Torres's summary decision on XRP might be appealed to the Second Circuit by the SEC, according to Mark Vagel, a former SEC attorney, who believes this is Ripple's greatest legal risk. However, the court needs to determine if XRP sales were securities before reaching a verdict on a fraud case. The point that the case might not have far-reaching ramifications even if Ripple is found to have broken the law was raised by both Bill Morgan and Fagel. In recent times, the dispute between Ripple and the SEC has intensified. The United States District Court for the Northern District of California recently rejected several important arguments advanced in a class action complaint against Ripple. Most class action complaints against Ripple in the U.S. have been essentially dismissed after Judge Phyllis Hamilton approved the company's move for summary judgment on federal class claims for unregistered and state law securities. For the business, this was a triumph in procedure. Chief Legal Officer Stuart Aldroti of Ripple's released a statement expressing his happiness with the dismissal. How XRP is classified as a security is up to the jury. The court did not make a ruling on whether XRP is a security, even though it dismissed the case. An important decision in this case will be made by a jury when they decide if XRP passes the Howey test. Additionally, Ripple CEO Brad Garlinghouse will stand trial in a civil securities action that a judge in California has ordered. The lawsuit claims that Garlinghouse made false representations in 2017 regarding the sales of XRP, in contrast to Ripple's partial success in New York. The trial will focus on determining whether his actions influenced the decisions that investors made, according to the United States District Court for the Northern District of California. After denying 4 more claims, the court came to this decision. The purpose of this trial is to have a split jury decide if XRP qualifies as a security. Judge Torres's interpretation differs from Judge Hamilton's ruling in the Southern District of New York. Since XRP does not fulfill all the conditions of the Howey test, its low value and the risk of a negative jury verdict, Judge Torres found that retail investors were deceived into thinking it was a security. Legal commentator Fred Rispoli brought attention to the California cases approaching deadlines, possible settlement, and motions for consideration. The court has ordered the parties to reconsider their motions to seal portions of their briefs by July 8, 2024. Designed to safeguard a single display only. After that, in their final ruling, the court will address these motions. July 2023 might see either a catastrophic event or a spectacular triumph for the SEC. The contentious mixed finding was handed down by Judge Elisa Torres of the Second Circuit. While ruling that XRP coins traded to ordinary users are not securities, Torres also determined that Ripple broke the law in its dealings with institutional investors. The regulatory landscape surrounding Bitcoin has been further complicated by this ruling, which has resulted in wins for both sides. In May of 2024, Christina Littman, a former employee of the SEC, dropped hints that the agency might not conduct any additional investigation into the matter. While Ripple is attempting to reduce the potential fines, which may exceed $2 billion, this tactic is in direct opposition to earlier court rulings, like as the Terraform Labs case, in which Judge Jed Rakoff rejected similar arguments. Hogan, an XRP enthusiast, said the SEC was set up to protect investors, but such hefty fines would cause Ripple to dump a lot of XRP, which would be bad for those investors. Received in a recent essay, Jeremy Hogan voiced his doubts on the SEC's prospects of prevailing in its ongoing legal dispute with Ripple. He cautioned that the case's outcome might be dismal regardless of whether the SEC's appeal is successful. The Supreme Court of the United States is hearing an appeal from the SEC. Despite the potential for success, the case will most likely be remanded to the trial court for additional factual evaluations. This is because the Supreme Court is unlikely to be able to handle the Ripple appeal, and the complexity of the case, according to Hogan's opinion, implies that the Securities and Exchange Commission (BC) may struggle to win the appeal. A more protracted legal process might be on the horizon after the SEC's initial triumph in this case. This matter was brought to light by the order of Judge Annalisa Torres at a district court in July 2023. According to the judgment, XRP tokens do not qualify as securities when they are sold to regular investors on exchanges. It was decided that selling Ripple coins to major banks was against federal securities laws. Finding the best position becomes more difficult due to the fact that many courts have reached different conclusions, as stated in the same ruling. An ex-SEC division chief named Christina Littman has speculated that the district court may keep considering Torres' decision if the SEC opts not to appeal the Ripple case to a higher court. For the time being, I ask that you subscribe to my channel and give my videos a thumbs up.